And then mute.
Are we ready?
Yeah, let's get started.
Temporary.
Let me put my cheaters on so I can see what I'm doing.
All this stuff, but yeah.
Like that? Yeah.
Ladies and gentlemen, I would like to call the BZA October 3rd, 2022 meeting to order. So let's, first thing on the agenda, please rise for the Pledge of Allegiance. I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Luann, roll call, please.
Mr. Fowler? Here. Ms. Harlow? Here. Mr. Horvath?
Here.
Mr. Trick?
Here.
Mr. Wolf?
Here. Next item on the, before we get to the next item on the agenda, please everyone silence their cell phones, which I forgot to do already. Come on. Come on. There we go. Okay. Do we approve the agenda or we go
I think we're amending.
amending it? Next item on the agenda is to amend the agenda.
I move, do we need a motion for that?
Or do we
Yeah,
approve the
I mean,
agenda?
You have to add something to the agenda and then make a motion to approve it.
Oh,
Okay.
I move we amend the agenda
To add an executive session.
to an executive session.
Well, to add that. That would be to add an executive session.
To add an executive session.
I
To
second
the
it.
agenda. Second? All in favor?
Aye.
Aye.
And so I'll kind of just, given that you've amended the agenda, my name is Scott Solomon. I am I'm an attorney from Shorter Mondrow, Barbary and Powers. I represent the township with respect to pending litigation. And I'm here today to request an executive session for the Board of Zoning Appeals to move, and the motion that I would request would be a motion moving the Board of Zoning Appeals to go into executive session in accordance with Ohio Revised Code 121.22G3 to discuss pending or imminent litigation with the township attorney, and also invite Mr. Snyder to join us as well.
All in favor?
All right.
If someone would make that motion, then it would be seconded.
Do we have to word it exactly the way you did?
Down to the
If you would make
G3.
just a
Can I
request a
say
motion to say what
your
you said.
motion,
There you go.
we move to accept your motion to amend the agenda accordingly.
Move to go in executive session based on the rationale that I set forth.
That's what we just
And then I would
said.
need a second.
Second.
And then a roll call vote, please.
Luann, roll call?
Very formal.
Mr. Fowler?
Yes.
Ms. Harlow?
Yes.
Mr. Horvath?
Yes.
Mr. Trick?
Yes.
Mr. Wolf?
Yes.
And then if we could go ahead and move an executive session, and everyone else will stay here, hopefully it won't be very long. We'll be back.
Okay. Let's go into executive session. I'd like to call the Board of Zoning Appeals meeting back in session and close the executive session. All in favor?
Aye.
Okay, approval of the agenda as amended. We never approved that.
Second.
We get a vote?
Yep.
Roll call?
Mr. Fowler?
Yes.
Ms. Harlow?
Yes.
Mr. Horvath?
Yes.
Mr. Trick?
Yes.
Mr. Wolf?
Yes. Okay. Those who are going to give
At this time, can I make a motion?
Yes.
I'd like to make a motion to withdraw our decision from BZA resolution modifying appeal number 2021-01 and its interpretation thereof.
I'll second.
Roll call?
Who seconded?
I did.
Mr. Fowler?
Abstain.
Ms. Harlow?
Yes.
Mr. Horvath?
Yes.
Mr. Trick?
Yes.
Mr. Wolf?
Yes.
Thank you, Board.
Okay. Next item on the agenda is swearing in. Those who are going to give testimony or think they are going to give testimony to this board, please rise and raise your right hand. The testimony you're about to give is the truth, the whole truth, and nothing but the truth? Yes. Thank you. Please sit down. First case is BZA 2022-06. Brian? Oh, it's, excuse me. Okay. BZA, I'll keep on going though. It's BZA 2022-06. I'm gonna screw this up, so forgive me. I want to say it's Yiwi Chang and Jared Tucker at 10112 Meadow Drive to challenge determination of zoning inspector that a conditional use permit is required for a short-term rental. Did I get that one right? Oh, thank you.
Good evening, Brian Snyder. Staff with Hamilton County Planning and Development prepared the staff report for this case. You should all have a copy of it. This is an appeal of a zoning violation that was issued for 10112 Meadow Drive. The notice was issued on June 27th, 2022 for operating a short-term rental use without the required conditional use permit. There's a long history on this property, which is detailed in the staff report. I'm not going to go into that. Suffice it to say that the interpretation, or the notice of violation was issued by the zoning inspector for the Symmes Township, Emily Whitty. That zoning violation is the subject of the appeal. Any decision of an administrative official is appealable to the Board of Zoning Appeals. We received an application to that effect. That's the point of case 2022-06. The appellant is represented by an attorney who argued that they are a legal non-conforming use, that they existed prior to the June 19th effective date of the zoning resolution text amendment that was approved by the Symmes Township trustees, and as such should be considered a legal non-conforming use. They submitted several exhibits to that effect, which you should have copies of, and they are here represented by their attorney for tonight's hearing. Staff's view is that they were not a legal non-conforming use because they were not a legal use prior to the amendment. They did not receive zoning approval for the use of the property as a short-term rental, and therefore they were not legally non-conforming when the amendment was approved in June. That was the interpretation that was made in the issuance of the zoning violation notice. That is the subject of tonight's appeal. Again, similar to the previous appeal on this property, this is an appeal, not a conditional use request. There is no Discussion about whether this should be conditional use, whether it should be allowed in this neighborhood, what the impacts of the neighborhood are. Those are all things that would come up if it were part of a conditional use hearing. This is an appeal. The question is before you is this a legal nonconforming use? Should the notice of violation that was issued by the zoning inspector stand? If that were the case, if that were the decision, the property would be subject to conditional use approval following the procedures laid out in the zoning resolution. If you find that they are a legal nonconforming use and you overturn the notice of violation from the zoning inspector, they will be a legal nonconforming use and will be able to operate legally on the property indefinitely as a short-term rental. So those are the facts of the case. If you have any questions, I'd be happy to try and answer them.
Okay. Let me understand, Brian. So the violation came on the 27th, and it's referencing back to the resolution that, or the ordinance that was effective on 6/19. Is that correct?
Yes,
Is that how I understand it?
correct.
So what you're saying is regardless of their history before 6/19, between 6/19 and 6/27, there was no conditional use permit issued, and therefore they were out of compliance with the ordinance of 6/19.
Whether they did or didn't get a conditional use, they were not a legal use. They did not receive zoning authority under several different interpretations that were in effect at the time. But that is all part of another case, a whole different BZA case than this one. These are the facts of the case for tonight's case.
Okay, so, and how did you determine that what was the basis for determining that they were not legal?
Based on the fact that they were operating as a short-term rental prior, they did not receive zoning approval nor request zoning approval for their use in that district.
Okay. Okay, the part that's not clear, Brian, is they were not legal relative to what ordinance?
The zoning resolution that was in effect at the time,
Which was dated or effective when?
prior to June 19th.
So what you're saying is because they were not legally zoned and they were non-conforming prior to 6/19, when the resolution was passed by the trustees and put into effect on 6/19, therefore that just kind of sealed it that they were non-conforming. Is that, I'm a little confused with some of this wording.
Typically with a non-conforming use, you have a use that was previously permitted in a district that was subsequently prohibited by a subsequent text amendment. This case was neither permitted before the text amendment nor was it prohibited after the text amendment. All we're saying is that they need to get conditional use approval for this use in this district.
So the ordinance basically said on 6/19, get a permit. You can continue doing what you're doing, just get a permit. Is that a layman's way of
Assuming
looking at
that
it?
it's a conditional use permit, yes.
Yeah,
Assuming that they get the conditional use permit, it's not something they can just ask for. Obviously, this board has to approve that.
right.
I don't understand. The ordinance was amended June 27th, is that right?
June 21st, 19th, sorry, June 19th.
That's when it became effective.
When in effect?
2022.
22.
Okay?
Which date did it become effective?
June 19th, 2022.
And that's the relevant date here? Until that date, you're under the old code, correct?
Yes,
And under the old code, Airbnb is not a conditional use.
correct. It was undefined.
It was undefined.
There were several interpretations, but it was
So
undefined.
there's no reason to request a conditional use of the township, is there? At that point?
At that point, no, there was no conditional use for specifically Airbnbs.
So there was
We did
nothing-
notify them at the time that they requested that they needed a conditional use prior to June 19th, 2021 as well. But that
Let's
case
stick
is
with June
pending.
19th for a minute. Prior to that date, Airbnb was not a conditional use, therefore did not require a conditional use permit. There's no reason for the homeowner to ask for a conditional use permit because the conditional use permit section of the code doesn't say anything about Airbnbs. Correct?
Correct. There was an interpretation to that effect, but it did not
So-
say that in the code. That's correct.
Where is the interpretation, if there is one, that on June 18th, they were in violation?
On June 27th, we sent a notice of violation.
That's June 27th.
Right.
And that's what's
June
before us.
18th.
That's what's before us.
Is
That's
June-
what we're talking about.
We're talking about the
June
June 27th violation.
Yeah.
Oh, you're saying there's a violation on June 27th?
Yeah, that was issued to the homeowner saying you need to go get a conditional permit. And they appealed that on July 15th.
We're not talking
And they
about
came back and said, no, we're appealing that.
Okay. So the new ordinance goes into effect June 19th. The day before that, the 18th, they were an Airbnb.
Correct.
The new ordinance goes into effect June 19th, and the code then says you're a conditional use, you need a permit,
All right.
and they don't ask for a permit. And then
Then they get
and then a
cited.
notice of violation is sent June 27th saying, for the last 8 days, you haven't asked for a permit.
The violation said you're operating an Airbnb where you need a conditional use permit. Yes.
Under the code currently in effect.
And you have a copy of the violation.
Okay, I understand. Thank you.
Okay. So what we're dealing with is the appeal to the violation relative to the ordinance on 6/19. Is that right?
Yes.
Yes.
I mean, yes.
Okay.
Correct.
Just trying to keep it clear. 'Cause it's
I know, I'm trying to remember the dates too.
very muddied. Okay. Okay.
Any other questions for Brian?
No. Thank you.
Thank you.
Okay, those who are going to be speaking for, please step up, give your name and address, please.
Good evening, my name's Sophia Hawley. I'm an attorney on behalf of the appellant. Can you guys hear me okay?
Yes, we can.
Loud
Thank
and
you.
clear.
Thank you. My bar number is 91361, and I'm at 1 East 4th Street, Cincinnati, Ohio, 45255. I'm joined by the property owner, Ms. Chang. I apologize because there are 3 appeals here. I feel I may be repeating myself. I hope it's not too boring. But to the extent that it's acceptable, I will try to keep my comments short. I would like to start by presenting testimony if that would be acceptable to the board.
Testimonies with regard to what, please?
Testimony with respect to the use of the property prior to the implementation of the new resolution.
I don't think that's an issue. I think we've all understood that it's an Airbnb.
I would
Right.
argue that it is an issue. It's my position and my client's position that because they were operating lawfully as a legitimate non-conforming use prior to the implementation of the new ordinance, when the new ordinance went into effect saying, okay, you got Airbnbs, you need to get conditional use approval, my clients did not require that under Ohio law because they were already operating as lawful properties. Go on.
So you have to define for us what lawful means, right?
Sure. So I'm happy to do so. And I apologize for reading. And if it would be acceptable to the board, to the extent that this line of questioning is applicable to all 3 appeals, I would like to just state on the record that I would like it to apply to all 3 appeals. So under Ohio law, a non-conforming use means a use that, quote, was lawful prior to the enactment of a zoning ordinance, and which use may be continued after the effective date of the ordinance, even though it does not comply with the applicable use restrictions. This is in each of the 3 appeals filed at City of Marietta, 2020 Ohio 5144. So essentially, zoning is there to sort of organize society. You look as though you want to say, do you want to ask a question?
No, please.
Zoning's there to organize society so that we can have certain uses in certain areas, and that's perfectly appropriate. However, to the extent that there's new zoning resolutions that are put into place, when something is already there, if you say someone can't use it anymore, that's taking away a property right. Because under this interpretation that you can make anything a conditional use approval and make anybody have to apply to anything, then there's just complete chaos. You can say to a whole neighborhood, single family residence is now conditional use starting today, and then you could send everyone in that neighborhood a letter. No one would do this, it's crazy, but it's the same application, a letter that says you must now apply for conditional use approval. Yesterday, you were operating lawfully as single family residence, but today you require conditional use approval, and you need to prove why you're allowed to stay here and continue using your property. Or businesses, same application.
Sure, that's a possibility, not a probability.
I agree, it's
Okay.
highly improbable.
So the question really gets back to the interpretation of the word lawful, right? And prior to 619, okay, it was undefined or ill-defined or misunderstood or not clear. So really the issue is it lawful or not lawful? Because if it's lawful, then what you're saying is true. If it's deemed not lawful, then they have to go get a permit. Is that?
Well, to the extent there was no restriction on people being able to rent short-term, long-term period. That just wasn't restricted underneath the prior zoning code. For that reason, I imagine we're all of you here for the prior hearings regarding this matter. It was initially, the property was identified as a bed and breakfast. There was a determination that it fell within the definition of bed and breakfast. There was evidence presented why that wasn't the case. Then this board came to the conclusion that it was a hotel or motel. I would argue that was also inapplicable. Those were both uses that did require some sort of approval. But if you look at either the definition of bed and breakfast or hotel, it certainly didn't fall within those restrictions. And as we sit here today, the use here for each of the three properties is a short-term rental, a dwelling unit or portion thereof which is offered or provided to a guest by a short-term rental owner or operator for a fee for a term of less than 30 days. So that's the definition of a short-term rental. We're dealing with the short-term rental. The short-term rental conditional use restriction was put into place on June 19th, 2022. Each of these three properties were operating prior to that date. One of the comments that was brought up in questioning that I would like to sort of touch upon is the question of whether there had to be a permit applied for. Ohio law actually addresses that too. The question of if something becomes a conditional use and you are a legitimate non-conforming use, do you then have to apply for a permit? And that can be the case in some resolutions, but that's not the case under Symmes Township. In each of the appeals attached to Exhibit C is a copy of the Symmes Township zoning resolution as it applies to legitimate non-conforming uses, and there's no permit requirement. And I apologize for being a dry attorney, but I must sort of highlight a case that I brought to your attention. It's for Billion 2021 Ohio 3850. This is in each of the applications. Where a zoning resolution provides an existing and non-conforming use may be continued but contains no provision as to a permit therefore, it is not necessary as a condition precedent to such continuance to secure from the zoning authority such a permit. So there was no obligation to request and obtain a permit in order to continue the legitimate non-conforming use. That's a combination of Ohio law and the Symmes Township zoning resolution. Certainly you could modify that for future non-conforming uses so that such a permit is required, but that's not required here under the zoning resolution as it stands today.
Are we ready to hear testimony?
Well, I mean, the testimony is, was it lawful or not lawful?
Well, and they have the right to present their
Okay.
evidence,
All
so
right.
I think we need
That's
to hear
fine.
that.
Absolutely.
Thank you. I'd like to invite Ms. Chang to join me. Could you please state your name for the record?
Yeah, my name is Yiwei Chong.
And are you the property owner for the property located at 10112 Meadow Mill Drive?
Yes, I'm owner with Jared Tucker.
When did you purchase the property?
In October of 2020.
All right, and I'd like to direct your attention, and I apologize for repeating myself, to the definition of short-term rental under section 31.3-192A of the Symmes Township zoning resolution. It defines short-term rental as a dwelling unit or portion thereof which is offered or provided to a guest by a short-term rental owner or operator for a fee for a term of less than 30 days. Do you understand this definition of short-term rental?
Yes.
And how have you used the property since you purchased it?
So I've been using it as a short-term rental and a mid-term rental.
And did you use the property as a short-term rental in 2020?
Yes.
Did you use the property as a short-term rental in 2021?
Yes.
Did you use a property as a short-term rental in 2022?
Yes.
And just to sort of beat a dead horse, we're using the property as a short-term rental prior to the implementation of the June 19th, 2022 zoning resolution
Yes.
we've been discussing here. All right, and then I'd like to direct your attention to Exhibit B to your appeal, which is in your packets. Could you please explain what these documents are?
It just shows the different guests that have stayed at the property prior to the zoning resolution has passed.
And so am I correct to say that these are reviews from November and October of 2021?
Yes.
And am I correct to say that there's also documents showing that you updated the terms of your rental in October 20th through October 28th?
Yeah, I think that just shows when it was created.
Okay. I have no further questions for you. Thank you.
We have questions.
Oh, I'm sorry.
Go ahead.
Chairman?
You can go first.
Since the time you've owned it, have you ever occupied the house?
No.
Has your co-owner ever occupied the house?
No.
Has it been continuously advertised for sale or for rental as a short-term rental that entire time period?
Yes.
Thank you.
Brett, did you have a question?
I'm just looking at these dates. Has it been rented every month since you've owned it?
Yes.
July, June, July. No other questions right
Okay.
now.
Thank you.
Thank you.
So can you explain to me the difference between a short-term and a mid-term rental to you?
So a short-term rental is any stay under 28 or 30 days, depending on how a regulation is defined. A mid-term rental is anything that is after longer than 30 days, but shorter than 12 months, which is what a traditional lease is.
Okay. Other questions?
What is the current use?
A short-term rental, I mean, it's still being used as a rental.
So is it being rented for 30 days? You just said, you gave two different definitions.
Yeah,
there of
so
short-term rental.
it could be rented for more than 30 days if somebody wants to stay longer than 30 days.
Okay.
Have you ever, any time since you own the house, considered seeking advice from the zoning board to see if everything's up and up? I know what the statute said prior to June 19th, but have you ever inquired into?
Yes, so when I first bought the property, I called Symmes Township and I asked if there were any regulations regarding rentals, and the answer I got was no.
But after June 19th, effective June 19th afterwards, you haven't taken any steps?
No, I didn't feel like I needed to ask anything after June 19th.
Even though the new statute, new regulation went into effect June 19th?
Yes.
And you'd had a month's notice that it would be in effect?
Yeah,
Why?
because I did not think that, because I believe that the use was legal prior to June 19th. So to me, that means anything after June 19th that starts being operating in this way is not allowed or requires a conditional use permit.
Were you advised by your attorney to think that way, or you just thought that way upon yourself?
I'm going to object to,
Yeah, you can't get an attorney-client
All right,
conversation.
I'm just saying.
respectfully.
Okay.
Okay,
Sorry.
but what was the basis for thinking it was legal?
Because prior to this regulation, that there were no restrictions in the zoning code. If there were, and there were interpretations of that, all of that were overturned or still in appeals, which is now, I'm kind of unclear if that's withdrawn now or something, but there's no definition saying that that is one. And ever since it has been operating, there's just nothing legally in the code that says that.
So did you inquire of legal counsel at any point prior to this?
Once I received the violation.
But not before you bought a $400,000 property?
No, because I looked in the zoning code and there was nothing regulating it.
Okay.
You understand the code now, right? Do you understand, and would you agree that you're in violation of it?
No, I
Let's back it
disagree
up.
that
Do you
I'm in
understand
violation.
the new code?
I understand the new code, but I disagree I'm in violation. I mean, to me, that means if I bought another house here or anybody bought another house here and wanted to start a short-term rental, then you would be required to apply for a conditional use permit.
Okay.
Do you own any other rental properties?
It's case number
Yes.
3.
No.
Sorry.
Like in general or in
Now?
general? Other than these, yeah.
Okay.
Is there any other questions?
Yeah, look, I mean,
For her
you can't-
specifically?
That was a pregnant question okay, you own other rental properties, or your co-owner also owns other rental properties. Are any of them in Symmes Township other than this property?
It's another appeal. There's two of
But
these.
other than the 3 appeals before us, do you own any other do you own any other properties in Symmes Township?
How is that relevant? I mean, I could say yes, but is that relevant?
Well, we want you to be truthful.
Well, I'm sorry, what did you say?
We want you to be truthful. Do you own other properties than these?
Yes.
You do?
In Symmes
In
Township?
Symmes
Yeah.
Township.
But how is that relevant to this appeal?
It's a question.
It's a question.
Okay,
You chose to give testimony, you're allowed to ask.
that's fine.
Are any of the other properties you own in Symmes Township owner occupied by you or your co-owner?
No,
Okay. But the only cases we have with you are just the 3 in front of us right here.
not all 3 are mine.
Right, I understood. I just meant the only cases that we're looking at are here, and your other properties in Symmes Township are not before us.
No.
Okay.
Any other questions? Thank you.
Okay.
Do we,
Is there anyone else that's going to testify?
Is anyone else here to talk for?
Do you want to talk for her case?
Oh, no, I'm sorry.
No.
You want to talk for your case?
No, it's for
Only
her
for
case.
her.
Oh, I'm sorry. I'm so sorry. Yeah, misunderstood.
Anyone
okay.
here to talk against?
I would like to address one of the comments or one of the lines of questioning that was made with respect to abandonment, sort of suggestion of abandonment of non-conforming use. To the extent that it was at least implied, under section 153 to the code, there is a provision providing that a non-conforming use is not abandoned unless it's voluntarily discontinued for 2 years or more. So just if any of these property owners just shut up shop for 6 months because they were having a surgery or a baby or parents were in the hospital, that's not an abandonment under this, under the Symmes County zoning resolution, which is pretty generous for Symmes Township. But I just would like to clarify that. And I would also, would it be acceptable for me to give closing arguments regarding just highlighting things?
Can you
No.
wait 1 second? I'm going to call Brian back.
Sure, of course.
Clearly from 619, there's no issue or discussion. It's crystal clear what needs to happen if a house comes in, and you or even said, Chang even said, if you have another house, okay. So what I'm trying to understand is how staff viewed Airbnbs prior to the clarification of the resolution by the trustees.
Staff viewed Airbnbs as a bed and breakfast, which require conditional use approval prior to the change in the code, prior to the decision of the Board of Zoning Appeals, which was ultimately appealed. In our conversations with the property owner and their attorneys prior to the code adoption, we informed them of that interpretation.
So staff's position was this was a non-conforming, non-legal conforming.
No, we didn't feel like it was conforming or non-conforming. We
It
felt
just
like
was.
it was a use that required conditional use approval. It didn't have it. It was an illegal use.
Okay, and that is based on what?
The fact that it was interpreted as a bed and breakfast, which required conditional use approval, which they did not either seek nor receive. Essentially, we told them it was a bed and breakfast, which required conditional use approval previously. We told them it requires conditional use approval now. Our position has been the same before as it was now. We never told them that Airbnb was legal before, and we said the same thing since the adoption of the amendment. There's more specific language in the amendment now, but they've never been informed by zoning staff that they're a legal use.
Okay, so in between 10/4/21 and where we are tonight, we've rescinded, gentlemen, we've rescinded that whole situation around bed and breakfast versus hotel. Okay, but what you're saying is your position is still that it was viewed as a bed and breakfast, therefore it was non-conforming and not legal.
Correct. Yes.
Have you had any other cases like this before, Brian?
No.
This is the first one.
I've had this interpretation, I had this previous interpretation in other zoning jurisdictions where it was upheld, but I did not have a situation like this.
In
specific.
Symmes.
Symmes is the first jurisdiction I work with that adopted amendments to add short-term rental definitions. So no, I'm not familiar with the case where we told them it was a conditional use, then the code changed, then we told them it was a conditional use. No. I have told numerous people in other jurisdictions that they're considered a conditional use, though.
Okay. Anyone else have any?
I don't have anything further for Brian.
Okay.
Thank you.
Is there,
I have a question for Ms. Chang and her lawyer,
And
because you're represented by the lawyer, so.
thank you.
You mentioned you had other properties in Symmes Township.
Yes.
Are they B&Bs?
No.
No?
No.
Okay. Okay. That's my question.
Yeah, I thought you guys might be interested.
I have can I provide some comments in response? So bed and breakfast is defined as a private owner-occupied residence with 1 to 3 guest rooms contained within that structure and operated so that guests reside at the home for not longer than 2 continuous weeks. No kitchen facilities may be provided for use by guests. So with respect to this first property, we're looking at SBZA 2022-06. Is that a private owner-occupied residence? As in, do you live in that residence?
No, and I believe we already discussed this in the last appeal that the Board of Zoning Appeals agreed that it was not a bed and breakfast.
And no kitchen facilities may be provided for use by guests. Are there kitchen facilities at this property?
Yes.
Is it available for rental for longer than 2 consecutive weeks?
Yes.
Okay, so based upon the definition, I graduated from elementary school. My elementary school definition of bed and breakfast, it doesn't look like this property can be a bed and breakfast. I can appreciate the need to modify the zoning resolution so that short-term rental is expressly defined as it is today, so that if I, Sophia Hawley, have enough time with my toddlers to open air bed and breakfast, I need to come to get conditional use approval for it. But prior to the date, it certainly wasn't a bed and breakfast as it's defined, and I think that's pretty clear from the definition based upon the facts here. It was an owner occupied, there was a kitchen facility, you could say longer than 2 weeks, like each of those things. It was not a bed and breakfast, and similarly, it wasn't a hotel, and for that reason, you all just withdrew your notice finding that it was a hotel as of this date, that you all agree with me, which is a good feeling on this one specific point. So the question is, what is it? It's clearly a short-term rental as it's defined under the code. Was a short-term rental legal when she started using it? It was. Was it legal when she continued using it? It was. On June 19th, 2022, was it legal?
It was legal based on what?
Legal based on, it was not excluded under the zoning resolution.
Okay, so it wasn't legal.
Explicitly excluded.
It's legal because it wasn't illegal.
Yes, it was a permitted use.
Permits?
It was a use that is permitted, and I'm using that under the
Not permitted like in
English.
a document.
Yes,
permit.
correct. And there was no permit requirement for it to be found to be a legitimate non-conforming use. So when the change happened, there was no obligation under the zoning resolution for a permit application. I mean, these are certainly changes that could be made to the resolution so that in the future they could be required.
Okay.
I have a follow-up question from earlier, because you said you had called the township to ask if, about zoning. Are you aware that they're not allowed to give legal advice in the township office?
I assume that the Symmes Township can answer questions about Symmes Township. I mean,
Do you know who you spoke to? Did you speak
No,
to a
I don't
trustee?
know who
Or did
it
you
was.
speak to whoever answered the phone?
it was somebody who answered the phone.
Okay. Thank you.
Okay.
I just have a few closing comments I could give, and then you can open up to the next. You can have a seat. Thank you very much. Just to summarize, and I think that we've highlighted the high points, the documents and testimony show that these properties have been used as short-term rental as they're currently defined prior to the implementation of the conditional use requirement. The documents and testimony show that they've not been abandoned, as in not discontinued for 2+ years. The zoning resolution does not require a permit for for continuation of non-conforming use. And under the facts here, we would argue they have a right to use this property. Ohio law provides that a non-conforming use is one that was lawful prior to the enactment of a zoning ordinance and which may be continued after the effective date. We would respectfully request that you all reverse the decision of the zoning inspector, and then just simply for appeal purposes, I have an obligation to say that on behalf of the appellant, if there's an adverse decision here, we will appeal to the Hamilton County Court of Common Pleas, but hopefully we don't have to do so. Thank you for your time and questions.
Thank you. Anyone to talk against? Okay, please come up. Were you sworn in?
I was.
Okay, please come up, state your name and address.
Thank you. Good evening. My name is Ned Portune. I live at 10113 Colburn Court, which is the house that is directly behind the house in question this evening. I am not a lawyer. One in our family was enough, so I will try to do my best here. It's interesting listening to all of this to me that the term Airbnb is technically defined as air, bed, and breakfast. They were operating as an Airbnb, counsel stating that they were operating lawfully. However, they also were cited in November of 2021 well prior to the date that we're talking about when everything changed for short-term rental. Because they were identified as a B&B, an Airbnb. They were identified that way because it was the determination of the zoning inspector that that was the best fit of zoning that was on the books at the time for that property. What they're arguing now is that after they appealed that, and we've gone through several rounds of redefinition, creation of short-term rental, that because all the time has gone through by now, because of the appeals, they should be grandfathered in and allowed to operate, and that they were not in non-compliance, even though it has been the zoning inspector's position the entire time that we have been in non-compliance based on what was on the books at the time to best define. It seems to me this is all based on semantics, simply because at the code, when the code was written, it could not predict every name that a rental could be named, every single piece of criteria for every named rental. Does it have a kitchen? Does it not have a kitchen? Etc. And what we're trying to do is split hairs based on semantics. Again, where the zoning inspector has been very clear the entire time what's been on the books, that they were not in compliance and needed to have a conditional use permit. So I would argue that that is where we still are. Thank you very much.
Well, I've got a question for you. When you say what's been on the books, what are you referring to?
I'm talking about the codes that were on the books defining different types of rentals and properties, which they were originally cited against in November of 2021.
So we have accessory apartments, we have bed and breakfast, we have daycare type A, we have granny cottages. Those were the definitions. Okay.
And they were determined to be a bed and breakfast at the time by the zoning inspector, because that was the closest fit.
Right.
Well, we need to maybe refute the statement he's making. As I understand it, that those rulings were rescinded by the township. The ruling that it was a bed and breakfast, am I mistaken?
The zoning violation that was sent in November was rescinded by the township, correct? I'm sorry, November 2021.
Okay. Thank you.
Anyone else talking against? Please come up and state your name.
My name is Kerry Kane. I live at 10120 Meadow Knoll, next door to the property in question. Just to back up Brian's history a little bit on what the township's perspective is, when I first learned that they were going to rent this as a short-term rental in November of 2020, I called Tom Stahlheber, who used to be a neighbor of mine in Delhi, and said, hey, could you do short-term rental Airbnb things in Symmes Township? He says no, because they don't allow B&Bs, because you have to have a conditional use variance for that. So I waited a year to see what was going to happen, and then I filed a formal complaint with the township, with the zoning, and that was the reason why they were cited in November of 2021 for running a bed and breakfast. So the zoning commission has been consistent in their thought process of short-term rentals and Airbnbs and bed and breakfasts kind of all being lumped in together in that category historically. And it also seems to be a question as to whether they were of quote-unquote legal use on June 18th. As far as I know, this body met in February and deemed them to be a hotel. This specific property was called the hotel. And that is not a conforming property. So as of June 18th, they were still, in my mind, they were still categorized as a hotel. And a hotel is not a conforming property use in a single-family residential area. So the question of whether they were doing something that they were allowed to do on June 18th and now on June 19th, it's not allowed because of zoning change. They were in non-compliance prior to that because they had been classified as a hotel, and as far as I know, the property was never rezoned to allow hotels to be there. So that's, it just seems to me like again, it's semantics, and you know, the air, and also within the township process of coming up with this resolution, the lawyer's explanation was there's a clear delineation as to how things would be handled if the zoning ordinance prohibited short-term rentals versus allowing them with a zoning conditional variance. If the zoning variance was written to say they're prohibited, then anything existing would have been automatically grandfathered in. But the lawyer's advice was if they're allowed with a conditional zoning use variance, then there is no automatic grandfathering, and they would have to go through the conditional use variance process like any new entity that may come on the books. That was the lawyer's advice to the township trustees as they worded that resolution.
Any questions? Thank you. Anyone else speak against? Were you sworn in?
Yes.
Thank you. Please state your name and address.
J. Batchelor, 10119 Colborne Court. I live behind the property here that's being discussed. And I think regardless of the Symmes Township zoning, with all the discussion around interpretation of what you call it or whatever, I think that after we've gone through many of the discussions, that the violation is really with the state and the description of residential, single family, that's what it's zoned at. There is no one residing there. We've already heard that she doesn't reside there, never did, intended this to be a commercial property that you rent out, and it says in the code, single family. We have people staying there that are not single families, and we have, you know, I don't know how you argue that 3 guys from Michigan in commercial trucks are a single family in a single family home. I can't understand how you can argue that an entire soccer team from somewhere is all one single family. And there have been many occasions where, you know, there have been many different families staying there for wedding receptions or whatever they're there for, parties or whatever. So I think the real violation is in the state code, where it describes this property and this neighborhood as a residential area, which is clearly not being, no one has resided there. And I don't know how you argue that residing there for 1 or 2 days is declaring residence, and it's not being rented to just single families. So by definition, it doesn't meet the state code for what this neighborhood was intended to be.
Any questions?
Any questions?
No.
I don't.
Thank you.
Thank you.
Anyone else speaking against? Please come up, state your name. Were you sworn in?
I was.
You were? Thank you. Please state your name and address.
Good evening. My name is Tom Campake. I live across the street. I'm at 11945 North Lebanon Road, so I'm across the street from BZA number 7 there.
We are hearing testimony on 06 right now.
We're only on 06?
Yes, we're still on. Sorry.
I'll
If
step
you
back.
have something to say,
I'm
we're
not
happy
on.
to let you say it, but
Don't
I
go.
just
Well,
want you
this
to be
this
aware.
could apply to all. You know, if if we want to follow the rule of this applies to all, I mean, we could do that.
Well, the rule is.
And really, my testimony is,
If you want to talk about this specific one.
Yeah, applying to this one.
10112 Meadow Knoll Drive.
You're a member of the community, resident of Symmes Township. You have a right to speak on this case, even though it's not your neighbor immediately.
okay, let me speak on this case, but let's apply it to all three cases.
Well, you may have to
don't
say it
apply
again.
to this
Can't do
one.
that?
You may have to say it again later. Get your practice in.
Yeah. We
But the
are,
whole point of having a single attorney here was to limit the duplication of this.
well, she'll be
That's why you're all here
duplicating, trust me.
tonight.
triplicating.
That's why you won't be here next
duplicating.
month.
Her-
She has to do it 3 times.
Then I'll wait. Yeah, I mean, if
Okay.
that's the case, I'll wait.
Okay,
Okay.
Because I don't want to waste everybody's time.
that is fine.
Thank you.
Okay, thank you. Anyone else speaking against? Any other questions? Are you speaking against?
Yes, please.
Okay, please state
I
your
was
name.
sworn in. My name is Kyle Watts. I'm at 11993 Streamside Drive. I'm basically just going to echo some of the things that have already been said. I want to make sure that people understand that, yes, this was essentially a bed and breakfast before. That was conditional use. This board made a determination that it was even worse than a bed and breakfast, a non-compliant in a residential neighborhood of being a hotel. So that took it even at a higher level. The township trustees came back and said, we need to clear up what this is so that it adds to the definition. Because they didn't want to disallow short-term rentals, so they defined it. And they didn't disallow them in total. They're just simply saying that we're going to go through conditional use, just like a bed and breakfast, just like anything else. And that's the only reason why the hotel one was taken away, because now it was better defined, because it applied to these ones that existed. And at the end of the day, we want to keep that going with the bed and breakfast and still allow these in Symmes Township with conditional use. The township is not saying we're disallowing these.
True.
Some of the folks here tonight probably think this is going to be put in place to disallow all short-term uses. No, it is case by case. There are many properties in Symmes Township would make great Airbnbs. In fact, there's probably some here that are talked tonight that would make great Airbnbs, where there probably may not be a lot of conditional use discussion on them. It is a case by case. It matches the prior discussion on Airbnbs. It was elevated to a legal use in residential neighborhoods. That's what this board said. And so I don't know how the board can go from completely illegal to, oh, just go ahead and continue to operate. So I want to just make sure we have the full history there. It makes sense that it's a bed and breakfast all the way through conditional use. It's been conditional use from the very beginning. We're just asking that continues on a case-by-case basis. We're not making any overarching decisions on all properties. Thank you.
Thank you. Any questions? Thank you.
Am I allowed to ask why?
No.
No.
No. Okay.
I'll ask you a question.
That's fine.
Again, my name's Kerry Kane, again at 1120 Meadow Knoll. I would like to know what date the designation of the hotel classification was removed.
Tonight.
By the board tonight, but I
Okay.
think he's also talking about.
So as of June 18th, the hotel classification still applied to that property. So it was operating in a non-compliant manner on June 19th.
That's a little bit vague. In conjunction with a private meeting with council, we're not too sure about the determination of that. It's our understanding on advice of council that the township rescinded their ruling of a conditional use that was from last fall, or a year ago fall, and asked us to rescind this case as a hotel for the same purpose of making it clear that the Symmes Township zoning ordinance is what governs. The date before the zoning ordinance and the date after, that everything else was rescinded. All those rulings were rescinded, ours and theirs, and that we're only looking at the code in front of us, 2 versions, 1 date and another date.
Okay, but your discussion earlier seemed to kind of hinge on if they were acting legally as of June 18th versus the 19th. So as of June 18th, they were still classified as a hotel and they were not operating in a conforming manner.
Not as I understand the conversations tonight, that our rescission and their rescission wipes the slate clean, that the only thing before us at this hearing tonight on these cases is what code was in place the day before and the day after.
Right, but
We are ignoring those actions that took place before and our own actions that took place before. That's my understanding.
Because your specific discussion seemed to imply that if they were doing earlier, was on June 18th, if it was a conforming, based on what was in place, a conforming activity, then it's one thing, and June 18th, if it wasn't a conforming activity, and then the new regulation went into effect on June 19th, it's a different perspective. So I'm trying to say that as of June 18th, it was not a conforming activity based on what was in place on that date.
That's the question before us. That's exactly right.
And
We have to sort that out.
As of that date, the hotel classification, as far as I know, was still in place, which is a non-conforming activity.
That's what the lawyers and everybody have to figure out.
Okay. But we rescinded that, which goes back to January 3rd. Okay, so let us do our process here, because there's a lot of things that have been said here that may or may not have been completely correct, and we've got to sort through all of this and come up with a decision.
Thank you.
All right, I have one question. I have a question or a clarification from Ms. Holly, if you don't mind.
Of course, not at all.
Thank you. So you're saying overall that this is not an Airbnb. This is a short-term.
Well, I'm saying that per the definition of bed and breakfast in the Symmes Township zoning resolution, it's not a bed and breakfast.
Okay, then I have another question.
Okay.
This property is advertised on Airbnb, which is Air Bed and Breakfast.
So I would say in response to that bed and breakfast is specifically defined in the Symmes Township zoning resolution. And there's a specific definition for bed and breakfast. And the use, based upon the testimony here, does not fall underneath what a bed and breakfast is. I would say that a bed and breakfast in Symmes Township is different than something that could be on Airbnb. I know from personal use that there are some bed and breakfasts that are on Airbnb. So I believe that something can be a bed and breakfast as defined by the Symmes Township zoning resolution and also an Airbnb listing. But this specific property, and this applies to all properties, but I am going to repeat myself, this specific property is not a bed and breakfast as defined in the Symmes Township zoning resolution, and I don't think there's any question there based upon the factors that have been defined as a bed and breakfast. And I don't think this is going to be a problem for new properties. I think new properties are going to have to clearly go through this process, but we're dealing with some of these properties that were in effect before.
Okay, thank you.
Thank you.
Brian, if you would come back up.
Sure.
Are properties with the intent to make them commercial enterprises permitted in single resident zones without a conditional permit?
Commercial uses are not permitted in residential areas with any permit.
So if you have a property that you endeavor to make it a commercial business, okay, and it's located in a residential area, you're saying that is not allowed?
No. Commercial business, what's defined as commercial business, is not permitted in a residential district. That's
Okay,
correct.
now let me be, because I'm not a lawyer, but I'm saying commercial, but that could also include bed and breakfast, daycare, granny cottages, anything that you set up as a business to create profit.
Correct. I'm talking about commercial uses as defined in the zoning code. There are other uses that are similar to commercial uses that were deemed to not have the impacts of commercial uses that were permitted in some capacity in single-family districts, like bed and breakfasts or schools or churches.
But if you have a property that you intend to use for profit, okay, maybe commercial is not the right term, and forgive me for my limited knowledge on this, but it's something else, but it's the intent and the spirit is to gain profit from that property in a residential area, okay, and you need to be permitted to do that. Is that correct?
So the issue with this has always been there are numerous uses that are not defined at the time that they become popular, at the time that they're invented or created or they begin being used that way. This happens all of the time in every jurisdiction.
Right, but you're talking about the details of what you call it. What I'm asking for is the intent and spirit of putting a unit, using a property, whether
Sure,
it's...
I'm getting there.
Okay, all right, thank you.
So when these happen, they're not just permitted there. If somebody came up with a new type of industrial use that nobody's ever heard of before and wanted to put it on a single family property, we would tell them that they're in violation because they're very similar to industrial use. And it would either take an attorney to argue that case or it would take an amendment to the code to address it, one or the other. But during that time, between when it gets created and when one of those two things happens, the job of the zoning administrator, in this case Kim Lipinski, is to make an interpretation of the zoning resolution.
Okay.
In this case she did, which was argued extensively, as discussed. But that was her job and she did it. And that was her interpretation. And the whole point of that is to try and find the use that's most similar to the type of use that you're talking about, which is what you're getting back to. So the impacts of certain conditional or certain business type uses are deemed to be appropriate in single family districts with approvals, and some are deemed to not be. And so you're trying to weigh which one this is, and you have to, as the zoning administrator, define it as something. Just because it's not defined does not automatically make it a permitted use, a lawfully permitted use.
So what I'm trying to do is get out of the weeds, okay? We're in the weeds, what do you call it, okay? And what I'm trying to do is bring it up to what is the intent, okay? And from previous cases that we've argued, we've not allowed businesses to operate in residential areas without being conditionally permitted.
Correct, yes.
Okay.
Except for home occupations, which is
home occupations,
which is just you with no external impacts and no employees and no staff.
Right.
I'm sorry, no customers.
As Mr. Fowler has demonstrated that the appellant has said, you know, it was unoccupied, so it's not owner occupied. It is strictly for business.
Those two things are not defined that way in the zoning resolution.
What aren't?
Owner occupied is not mentioned in the zoning resolution because
The fact that it's not owner occupied lends itself to being more like a business.
When you're dealing with a residential use, the term owner occupied, if it were in the zoning resolution, would be illegal. It would violate the Federal Fair Housing Act, where you're not, as a zoning authority, allowed to regulate whether you rent your property or not, except in circumstances where you're renting your property to somebody on a short-term basis, like bed and breakfast. Otherwise, it's a residential use. Otherwise, it is a single-family residential use.
Well,
which
let me-
does not
let me-
require you to be a single family. It does not require you to be related, because both of those things would also violate federal law.
We're getting well afield of where we are, the issue we are facing here tonight, but just for clarity, owner occupied is mentioned in the zoning resolution at least 4 times, and they are all in the category of conditional use. And in the old zoning code.
I apologize, you're correct.
Yeah.
I just meant it wasn't defined in the
Yeah.
residential
I
portions of the code.
understand.
I
I just wanted
apologize.
to make that
That is an
point.
error that I
And
will
that was
freely admit
part
that I
of
made.
how we got here, was because every category of conditional use, until the new zoning resolution was passed, all of those, bed and breakfast, mom and pop, or whatever it was called, grandmother's suites, they were all owner occupied. So, but that's all aside the point. We need to get back to what is tonight's issue.
Thank you. And again, I apologize. You're correct.
Okay.
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 All
Thank
done?
you. Yeah.
Okay, so, closing testimony, let's go into deliberation. Let's start right here.
I'm for affirming the zoning inspector's issuance of a notice of violation for short-term rental use.
I would agree with that, and my point here is through the revelation of these discussions is the whole notion of that its intent was for business, and we're not going to do that, not in our residential areas.
I am not in support of the motion you're suggesting. I think there is great jeopardy here for denying due process to the property owners. I think what you have is an unfair administration of the zoning code here. You're talking about an effective date of June 19th, 2022 of a zoning ordinance. As I'm reading the staff report, it passed June 19th, 2022. As I hear from the testimony tonight, between June 19th, 2022 and June 27th, 8 days later, the property owners were not given any notice of the change in the zoning code, and they're being told now that they're in violation because by June 27th, they got a notice of violation that they were an illegal use. Somehow that doesn't seem right to me. If you're trying to wedge them into June 19th's new ordinance and say that they have to apply for conditional use, you gave them only 8 days to do it, gave them no notice, and you're telling them...
I completely take
They're-
issue with that. They had notice.
Me too.
The trustees...
Before June 19th?
Yes, the trustees regularly publish what they're going to discuss. They passed it back in May.
Yeah.
They had nearly 30 days notice. It was not done on this day.
Yeah.
And then going after them. They have time.
Yeah.
So that's the May 19th issue.
Okay.
Okay.
Just like every other citizen in Symmes Township.
Um,
If you guys are just
okay,
learning
I
that now,
understand.
you get to look at the Symmes Township website, and there's information there all the time that nobody pays attention to. It's okay.
At your own risk.
Yes, whether you're a business or an individual.
Okay, I see your point. Somehow I think they're being screwed. And it's on a technicality, and it bothers me.
Okay.
I am against Airbnbs in our township. I'm totally against it. But I feel these homeowners are being shafted in a manipulated way, playing with the rules.
Well, you've heard testimony from the people who are adjacent to the properties as well.
Oh, I
Their
understand.
property.
Like I said, I'm opposed to Airbnbs. I just
And
am.
conditional use permits
But-
is part of the due process. And if they
I-
don't get the
I
answer they
hear
want,
you.
just like like they've done before, they know how to appeal to common pleas. She's now aware that, legal advice is a good idea here, and she has clearly saw it both her and Jared. Sorry, I don't mean.
I
to just say
understand the
her.
technicalities. You're entitled to your vote, I'm entitled to mine. I think they're being unfairly treated, it bothers me.
Okay. Noted.
Gary?
Wow. I've listened to both sides, and the plaintiff has brought up some very good points. But I don't feel that that's our decision right now to consider. I don't feel at this point. Our point is Brian's report. Do we agree with it, or will we rescind it? And it was clearly stated on June 19th that the definition of rentals have changed. I agree. We are not telling the individual that you cannot have a rental. We're just saying that you now have new restrictions, 30 days or more, and you can still have your rental. So we're not denying that right to the individual. We are concerned about things that have happened prior to this, and I think that we agreed to rescind that it was going to be rescinded. And I figure that, yes, they have some good grounds. My decision is let the courts decide, let the attorneys decide. They're going to file an appeal. If it doesn't approve, let the courts decide. Let our attorneys decide with their attorneys. I am voting in favor of Brian's report.
So for the zoning inspector.
He's affirming.
I'm for,
Okay.
on those reasons.
Go with what Brian's saying. Giving them a week's notice is basically, to me, doesn't make sense to me. They should have given them a longer lead time, even though they did have notice, in their website and all of that. I wish they had more time to absorb what was going on. But I do agree with you, Gary, that they were given notice, and I do think the courts need to hash this all out, because I think it's well above us right now to figure this thing out. I don't like Airbnbs or short-term rentals or whatever we want to call it in a residential area, but it is what it is, and I think we just have to go with what Brian's people say.
So that's an affirmation?
Yeah.
You affirm, okay.
I move to affirm the decision of the zoning inspector in issuance of a notice of violation for a short-term rental use without conditional use approval for the property located at 10,112 Meadow Knoll Drive. This is also BZA 2022-06.
I'll second it.
Will you base that on the findings in the staff report? Did you?
Yes.
I'll second that.
You ready?
Roll call.
We're never ready, but let's do it anyway.
Roll call.
Mr. Fowler?
No.
Ms. Harlow?
Yes.
Mr. Horvath?
Yes.
Mr. Trick?
Yes.
Mr. Wolf?
Yes. Okay. Next case on the agenda, BZA 2022-07, Aaron and Kristen Landlot, 11-922 Lebanon Road. Challenge determination of the zoning inspector that a conditional use permitted is required for the short-term rental.
Good evening, Brian Snyder, Hamilton County Planning and Development. Again, there is a staff report for this case. Most of the findings are similar, but I will go over it. This is case 2022-07, as you stated. This is also an appeal of a notice of zoning violation that was issued June 27th, 2022, notifying the property owners that they were operating an Airbnb without the required conditional use permit. The dates related to the text amendments are the same. Staff's position on this case was the same. Essentially, they were, in our interpretation, conditional use previously. That interpretation was questioned at length. The notice of violation stated the same thing. This is a use that requires a conditional use. It was consistent before and after the amendments. This use was not legally or lawfully in existence. There was, to my knowledge, no discussion with zoning staff related to whether this would be a permitted use. There was no indication that it was given by staff to the property owners. And clearly now they are not legal non-conforming if they were not legal previously. That's the same position. All of the same staff report findings are in effect for this case as well. This is not a discussion about whether it should be a conditional use or not. It is an appeal of a decision. The determination of whether or not it is a legal non-conforming use is being challenged by the property owner, the appellants and their attorney. If you have any questions, I'd be happy to try and answer them.
I don't have any.
What, if anything, is different between this case and the previous case?
This case doesn't have the lengthy history in court that the previous one did. Other than that, it's the same.
So to Ms. Harlow's point, this was published on May 19th that this was going to be coming forward, and then it was
Correct.
effective June 19th, and then the violation was subjected on June 27th.
Correct, and to go further back, the Township Zoning Commission had a hearing on this like 2 or 3 months prior to the hearing on by the county commissioner or by the township trustees. So there was more discussion on the website, since you mentioned that as a possible place for notification. And I will state that what we sent them was not a ticket or a violation. We sent them a literal notice of violation.
Which means?
That we provided them notice.
That they're in violation.
Correct. They have 21 days to fix it after they get the notice, or to appeal, or to apply for approval.
So they really had more like 120 days, 150 days before they absolutely had to be in compliance.
Correct. And on top of that,
From the time of
trustees,
taking comments to...
the trustees initiated the text amendment at a public hearing even prior to the very beginning of the text amendment process. So there was a lot of public discussion about this prior to June 19th.
And you're sure that they received the notice? And is there any comment?
They certainly received the notice of violation where we gave them an additional 21 days to appeal or file for permits.
So they could have...
Or cease the use.
They could have they could have remedied the situation by either getting the permit or ceasing use. And
Either one, yes, correct. That's essentially what the notice of violation gives them, is notice that here's your notice that you're in violation of zoning, and it says you have 20 days, not 21, I apologize, 20 days from the date of the receipt of this notice to, and I think it says amend it or appeal it. You may appeal any decision by filing the appeal within 20 days.
So you can permit, you can cease, or you can appeal.
Correct.
Okay.
I must have not read far enough. You're saying that, never mind the adoption of the code in June or the passing of it in May, you're saying that you sent them notice on June 27th that they're in violation, and they had 20 days from then to apply for conditional permit.
Or cease the use or
cease
appeal.
the use
or appeal.
appeal.
Correct. Yes.
So they could have applied for a conditional permit like anybody else under the new code has going forward. They had that same opportunity then.
Correct.
Including specific notice from the township that that's their opportunity.
Correct, yes.
And they took no action.
They appealed that notice of violation
that's
tonight.
why we're here.
That's why we're here, correct.
Instead of asking for the conditional use
Or
permit.
ceasing, yes, right, correct, you're right.
Okay. So, appealing that, what is the impact of that on their right to a conditional use permit?
It's this, they have the same, you have the same options for this case as you had for the last case. I mean, you can uphold the notice of violation that was issued by the zoning inspector, or you can not.
No, I'm asking about what their options are. They've now lapsed by appealing. What is the impact of that on their right to a conditional use permit?
Apologize, they can apply for a conditional use permit anytime that they want, if they wanted to. The notice of violation, we as staff put all of our enforcement actions on hold when an appeal is filed. We can't cite them while they're appealing the first notice that they got.
Right.
We
Okay.
feel like the appeal needs to have happened before we can move on to the next step.
So are you telling me that they can tomorrow file a conditional use application and come back here before this board again for that determination, because that's where conditional use applications go?
That would be a conditional use hearing, would be back before you again, correct? And then at that point, that discussion would be about whether they meet the criteria for conditional use for the use, and all the neighbors would have their opportunity to discuss the impacts or whatever their findings on what those conditions would be.
I
Yes.
wish I had been smart enough to realize that 2 hours ago.
So what they're going to do, possibly, or can do, they file the conditional use, it goes to you, they get rejected by you, let's say.
It's not an appeal like a zoning variance would be. It's a conditional use. You just make an application for. You're an applicant for a conditional use, not an appellant. But anyway, I just wanted to make that clear that we don't deny you a conditional
You
use
state
permit.
your case and you bring it to us.
Correct.
We hear the pluses and the minuses.
And again, that's
Right.
because the use that you're asking for a conditional use for is not a prohibited use. Otherwise, we would
Right.
deny it.
Brian, I just have a general question, just for my knowledge.
Yes, sir.
okay? What's the conditional right permit fee? Or is there a fee with that application? I mean, is it a standard, or, I'm just figuring out, just for my own
Yeah,
knowledge.
there's a fee.
There is. There's a
Just
fee for
curious.
conditional uses, and it's not cheap. It's like $800.
$800. So each use, following the new regulation, if they wanted to rent it out of the property, it would be $800.
Each property, not each
It's
time they
property,
rent it.
not,
Not
once
each
you get
rental.
a,
It's not each rented,
no,
it's
no,
for
once
each
you
property.
get
Each
a
property.
property conditional use permit, boom, you got it.
That's your new zoning.
And
Yeah.
is that permanent, or is that a 12-month period?
No, that's permanent.
No, there's legal arguments on whether you have the authority to limit a conditional use to a certain amount of time. I would suggest that you don't, and even if you did, that you wouldn't do it, but
It's a zoning category, it's as simple as that.
That's a hearing for another day.
that's exactly, it's not what,
Let's
to
move on.
clarify, we're not here for a conditional use tonight. Tonight, they are just appealing the notice of violation that they received, and they're claiming that they are a legal non-conforming use, which the findings in the staff report are staff's case for why we sent the notice.
Got it. Thank you.
Any more questions for Brian? Okay, thank you,
you.
Brian.
Thank you.
Those going to be talking for, please stand up. State your name and address, please.
Hello, my name's Sophia Hawley. I'm legal counsel for the appellants relating to this appeal. My attorney number is 91361. I'm at 1 East 4th Street, Cincinnati, Ohio 45202. Thank you, everyone, for your patience and attention. Thank you, Mr. Schneider, for all of the work you've put into this specific appeal, as well as the others. And I'm here joined by representative for the appellant. Could you please state your name for the record?
Sure, it's Aaron Landolt, reside at 11187 Marlette Drive, Cincinnati, Ohio 45249. And this is regarding the property at 11922 North Lebanon Road.
And who's this young lady next to you?
Kristen Landel, reside at 11187 Marlette Drive, Cincinnati, Ohio 45249.
And are you all residents of Symmes Township?
No.
You're residents of Loveland?
No, Sycamore Township.
Sycamore Township, okay, understood. I have a few questions I'd like to ask you relating to the property. When did you purchase the property?
December of 2020.
And I'd like to direct your attention to the definition of short-term rental under section 31.3-192A of the Symmes Township zoning resolution. It defines short-term rental as a dwelling unit or portion thereof which is offered or provided to a guest by a short-term rental owner or operator for a fee for a term of less than 30 days. Do you understand that definition of short-term rental?
I do.
And how have you used the property since purchasing it?
It's been a short-term rental, and I learned a new term, midterm rental, tonight, so it's been a midterm rental at times as well.
Did you use the property as a short-term rental in 2021?
Yes.
And did you also use it as a short-term rental in 2022?
Yes.
And just to be absolutely crystal clear, were you using the property as a short-term rental prior to the implementation of the June 19th, 2022 short-term rental conditional use requirement?
Yes, we were.
All right, let's look at Exhibit B to your appeal, which has been provided to the board. Can you please tell us what these documents are?
Yeah, the first page is just showing the establishment of the account for the listing as April 2021 was the first time we booked it. And then I just printed out all the reviews that we've had from guests, ranging anywhere from, a minimum of 2 nights up until I think 6 months was our longest. So yeah, we've got all the reviews in there that explain when the units were rented.
I have no further questions for you all. If the board has any further questions, they'd be happy to answer.
I don't have any questions.
Yeah, I too have to think about it a moment.
Sure.
This is mostly for the attorney. As I understand it, your client is appealing the ruling. What is it you are appealing? Say it, you say it.
We are appealing the determination that a conditional use is required. It's our position here that the use is permitted because it's a legitimate non-conforming use.
Okay. Now let me parse that a moment because I was trying not to parse things a while ago. Now the Board of Trustees changed the zoning ordinance effective June 27th or effective June 19th to provide that to have a short-term rental, you had to have a conditional use permit. And you're saying you were grandfathered because you were in that status before the passage of that act.
Yes, that's correct.
And the violation notice comes from the zoning inspector saying you're in violation because you don't have a conditional use permit. And you're saying I'm grandfathered. That's the basis of your appeal.
Yes, that's a good summary.
Okay, thank you.
Thank you.
Does anybody else have questions? Or are we thinking?
I just have one more comment, if that's okay. Yeah, so the notice that we did receive, the first communication we've gotten from anybody at Symmes was after that June 27th notice. We didn't even know that we were in any type of violation or perceived that there was any kind of hearings going on about this. I should check the website. But at the same time, when I did get that notice, I did call Emily Whitty here and asked a couple questions because I was confused on, well, what does this permit entail, and what happens if I get rejected? And she advised to better reach out and call an attorney. So she did advise that she couldn't answer that question. Just wanted to let you guys know that. So.
And I guess one of my follow-up questions is, did you consult with an attorney before you purchased the property about zoning?
No.
Was it your intent to have this be an Airbnb, VRBO place at the time of purchase?
Yeah. Either that or whatever, just regular rental or a short-term Airbnb. We have done one before down in another state. So.
And but you didn't? Did you look up any zoning issues since you're in a different township?
Yeah, I couldn't find anything, in the search online or with Hamilton County or anything that talked about that in Symmes Township.
Okay. I don't have any further questions. Does anyone else?
No. Thank you.
Is it possible for me to ask a question?
Sure.
Did you talk to anybody at the county zoning office about Symmes Township zoning?
I did not.
Okay, thank you.
Okay.
Great.
No other questions. Thank you.
Can I make some final comments, if that's all right?
Sure.
Okay, thank you. So just a couple things. First, I think the question here is this a legitimate non-conforming use? That's the real question. And
I think the question is whether it's legal or not.
A legal non-conforming use.
Is that the correct word?
Yeah, that's right.
So it's our position that it is. And it sounds based upon my experience in previous cases before this board, that possibly that's a decision that's going to need to be decided in a court. But be that as it may, to the extent that my clients were permitted to use the property, they weren't required to get prior use. There was no requirement for them to get conditional use approval. And I think we should look at the history here. So how Symmes Township treated Airbnbs. Initially, they found that they were bed and breakfasts. Then there was a conclusion that that isn't quite right. And so then there was a finding that it was a hotel. And then there was a determination that was not quite right. And then there was a specific amendment to the zoning resolution relating to short-term rentals, which is in effect today. To the extent that this use was prohibited prior to that change, why was the change necessary? Why was it necessary to put in this change such that short-term rentals are conditional use?
Because at the January hearing or February hearing, there was 30, 40 citizens of Symmes Township, and they're all going, why don't we have a specific thing here to make this super clear to people who only want to do the Control F search on websites and stuff to find out what the zoning issues are?
So I would say I agree with you there that in this January hearing, it wasn't restricted. It wasn't restricted in the zoning resolution.
I didn't say it was not restricted.
No, that's not what she said.
Oh, well, I'm certainly not trying to put words in your mouth.
You've done it a couple times, so I'm just correcting you at this point.
Okay. I certainly apologize, and what you've said speaks for itself, and I'm here just as legal counsel. But let me move on to just saying final remarks. The documents and testimony show that the property has been used as a short-term rental prior to the implementation of G 2020-52, prior to this June 1922 implementation of the short-term rental restriction. The documents and testimony show that it's not been abandoned as defined by the Symmes Township zoning resolution, which was for 2 years. The Symmes Township zoning resolution does not require a permit for a continuation of a legitimate non-conforming use. And as a result of the Symmes Township zoning resolution that was in effect when the use began, which was in early 2021, this is a legitimate non-conforming use, one that was lawful prior to the enactment of a zoning ordinance, in which use may be continued after the effective date of the ordinance, even though it does not comply with the applicable use restrictions. This is City of Marietta, 2020, Ohio 5144. We respectfully request that the board reverse the decision of the zoning inspector, and for appeal purposes, I state on behalf of the appellants that we intend to appeal any adverse decision to the Hamilton County Court of Common Pleas. Thank you all for your time.
Thank you. Anyone else going to speak for the appellant? Anybody else can speak against the appellant? Okay. Please come up, state your name and address, please.
Well, we'll try this again. My name is Tom Campake. I am at 11945 North Lebanon Road, almost across the street from the 11922 property. I have lived out there for 26 years. This whole situation really came to my attention just a couple of months ago. I am not an attorney, but I am a retired architect, a certified building official with the state of Ohio. I am a certified building plan reviewer with the state of Ohio. I am a certified building inspector with the state of Ohio. I also participated 5 years on the BZA for Sharonville. So I tell you this, not because I'm trying to, toot my own horn here. I'm telling you that I've got some experience in these matters. They are very complicated. The building codes that define the building safety for all occupants realized many years ago that there is a very distinct difference between short-term residents and long-term residents. The differences are long-term residents are very familiar with their surroundings. They take pride in their surroundings. They maintain their surroundings. And if a problem exists, they generally get the help of others from nearby, and they help others nearby. Short-term residences generally do none of these. They become very complacent and follow the herd mentality when any kind of a problem does arise. Examples of what some of the differences are shorter travel distances to the exits, fire suppression and fire alarm systems, and the exclusion of cooking appliances in the rooms are all in rental units, short-term rental units. None of those are generally required to that extent in long-term residential uses. This is the building code now. The building code is saying there's a difference. That is precisely why hotels, dormitories have so many safety requirements that are required, that are not required of long-term residential facilities. The same is generally true for the intent of the zoning codes. There are differences. Residential zones are generally separated from most other classifications because they are just not proper to coexist. Look at the colors on that map. You don't see many colors inside the yellow areas for a reason. The code, however, does recognize there are some uses that are allowed to be located within residential use areas and without conditional approval. Examples of this are renting out your house for long-term uses. Anybody can do it. It's a business. What happens when the people get old or they want to move out for a while? They can rent their house out and they don't need conditional use for that. But that is generally for long-term uses. So it's the same thing occurring in the same area. Short-term uses are not permitted to have in-room cooking, just like a hotel. You're not allowed those things in hotels. They're not safe. That's why you don't have those in long-term use areas. Short-term rental units in residential zones has really never been a problem in the past. It hasn't been a problem because it just wasn't done. And if it was done, it was over before anybody even knew about it. But now, because of the internet, people are continually trying to supplement their income, and with the new online rental systems like Airbnb and VRBO and others, there's more coming on every month. It is happening in these areas with a much greater frequency, and something has to be done about that. So now it's come here to our township. It's here in Symmes. What are you going to do about it? Something has to be done. My general experience with Aaron and Kristen, having lived across the street from this for a year and a half, is they have been great. There has been no problem. I didn't even know about it until just a few months ago. Now, I have recognized the fact that there's been a lot of cars there, different people, but they haven't been a problem. They haven't been noisy. They keep their place up. They're taking very good care of it. They're doing a pretty good job. But typically, people that rent these properties do not have as much respect of their surroundings because they paid money for their place. Their feeling is, hey, I paid for this. I can do what I want here. I can have fun. And as long as they don't damage the property, the owners don't really care either because they're getting their money, their property's not being damaged, it's okay. But what kind of qualifications are they actually getting on the people that they rent to? Are they the same kind of people that would normally be there for long-term rentals? Or are they maybe some drug dealer that's shopping around houses? We're going to operate here for a week or two, then we're going to move. They'll never catch us. What are they doing? They don't know. They're not doing those kind of reviews on these people. They can't afford to because these are short-term rentals. Anybody that puts down their money can rent this space. That's not the kind of people I want in my neighborhood. With kids running around and everything else going on, you never know what's going to happen in the future. You cannot predict what's going to happen in the future via what happened in the past. Clear example of that is Hurricane Ian in Florida. It just destroyed the place, yet it never had before. You don't know. Something has to be done about this. Bottom line is, I'm trying to make it very, very clear, and the word's been thrown around a lot tonight, that short-term rentals are distinctly different than long-term rentals. Don't put short-term rentals in those yellow areas. And you need to find a way to do that. Find a way to make that happen. Lastly, I want to say that it's not the building itself that describes what goes on inside it. It's what goes on inside it. There are many things you cannot put in these yellow areas. You cannot put a business in there. At some point in time, if a guy's making furniture in his basement and it keeps expanding and expanding and expanding, it gets to a point. Now, where is that line? I don't know. But there gets to be a point where that business is now too large to be in that residential area because of materials that are being delivered, because of noise, because of dust, because of safety. What happens if that building burns down? You now have a greater likelihood of fire. So you have those issues to consider. I mean, that's why you can't operate a warehouse in those areas, or a restaurant, or a propane storage facility. You can't do that. And you got to make sure that that doesn't happen here, because we don't know what's coming down the road. Now, as far as whether a use is identified in the code specifically or excluded specifically, there's a big area between. That's the gray area. The codes can never define everything that is going in. The codes are there to try and establish an intent. And it's appeal boards like yourself that really are tasked with defining that gray area. So I challenge you tonight, you need to define that gray area. I spent my career in that gray area. It's not a fun place to be, let me tell you. Any questions for me?
No, I'd just like to say thank you for your time and the effort you put into developing the information. I would say, though, that that would be more appropriate if we were doing a conditional use permitting to decide how to use the property. And I would say that, it may be more needful for you at a later date to bring those points back to us.
I can give you my telephone number and you can call.
No. When and if there is a conditional use permitting question, those are the types of discussions that we would want to entertain at that time.
Well, the biggest reason why I'm here tonight is I got a letter from Symmes, just a copy of what was being applied here. Last week, I guess it was. I'm not even sure the date on this. It hasn't been too long. I was aware of the usage before that, but I was not aware of, quite frankly, the severity of this.
But what's actually in front of us is to accept the, what the building department is.
I understand, but
That they've approved or not.
I'm not in a position to be able to come back to the board every time the board meets to review these things. And you probably don't want me back here that often.
Okay. You're more than welcome to.
Thank you.
Make a suggestion. Stay in touch with the, make sure you sign up and get the monthly Symmes Township newsletter.
I already get it.
You got it. Okay.
There you go.
There you go.
Thank you.
Thank you. Thank you.
Anyone else talk against? Okay. At this point,
I'm sorry, there is one thing else I want to say.
Sure.
make it quick.
It is quick. I do not feel it is fair to the owners of the property. I'll push this over. To the owners of the property to exclude them from operating and using their property. They're caught in the middle here too. They had very good intent, I'm sure, when they started this thing. They are very good owners. They take very good care of the property. I've never met them, never talked to them, still haven't. But it's not fair to them to force their doors shut quickly like that. I think, well...
Nobody's forced their doors shut.
Right.
We're not forcing their doors shut.
What if a conditional use permit is not granted?
Well, that's for a different conversation on a different day.
Different time, different...
Let's not muddle what ifs. Let's talk about what we're dealing with here today. But thank you very much. Appreciate it.
Thank you.
Good job.
Okay, at this point, I'd like to close testimony and go into deliberation. Okay, let's start at the far end.
I ceded my comments to Brian.
Oh, pass it down to Brian. Okay, Gary, thanks.
Experience first.
My thoughts on this have been bouncing around all over the place. Let me give you the new thought, and that is, in my subdivision, we have, our subdivision rules prohibit yard barns, no backyard shed. And if the township were tomorrow to prohibit backyard sheds, those people who have backyard sheds today would be grandfathered. The funny thing about this case is everybody's fighting over this issue of conditional use. If the township had simply said no Airbnbs, period, as opposed to putting it in the conditional use category where they say, well, you maybe can have one if you go get a conditional use permit. If they had said no B&Bs, period, these people would not be here tonight under this appeal. They would be grandfathered. Am I mistaken about that?
Right, but that's not what was determined. Nothing's prohibited. It's get a conditional permit. That's what the trustees have said.
But the same issue applies. The rule was put in, and they were in compliance before the rule was adopted. I think they're grandfathered. That's my opinion and my vote.
Okay.
So you neglect, you reverse?
Yeah, I'm going to be against the staff position.
Okay, let's look at it another way, and this is just me, Brian. If you had a car that didn't have a license plate on it, it was the rule of the land, you didn't need license plates, and now you need the license plates, and you get a ticket for not having a license plate, because it's the rule of the land. What do you do?
Well, the rule of the land doesn't have a statutory or common law rule of grandfathered status. We're talking about property rights here and the ownerships of someone's lands.
Well,
Totally different issue, in my mind.
you know, I'm not a lawyer, I'm just
So he
thinking.
reverses. Let's keep going. It's getting late.
I hear their arguments, and I certainly have a sympathetic ear in their position. But it goes back to my belief that it is not our decision to make that decision about that. We are dealing with June 19th, and if there is a violation following that. Let the courts decide what has happened prior to that time, if they should be grandfathered in. I just don't see that as my responsibility, my
So
position.
do you affirm or reverse?
I am affirm the.
Okay.
I affirm.
I affirm.
I mean, I'm in a firm mode. I think that in reality, I mean, they got the notice. They could file for a conditional use, and
Oh, they still can.
and they still can, and move forward. So I think that's the way I would go right now.
I affirm, and Brian, just to your point, I see this similar to a fence case. We've told people to take down fences. This is not horribly different from that. It's just a grander scale as far as finances. Instead of costing somebody $10,000, it's costing something substantially more, and that's kind of a contingency thing, if they don't do the conditional use, if they don't do the long-term planning, or renting, sorry. So that's my point of view, but
Yeah.
I affirm.
But I don't think it's a fence issue.
Let's go with the motion.
The fence was not permitted when they built it. When these people made their properties Airbnbs, it was not prohibited.
Well,
You know,
I disagree,
the motion.
but let's
I
do the
understand.
motion, so
Put a motion.
we'll get our disagreements
Let's
out.
get a
The law is
motion.
the law right now.
We're not
so-
going to change it.
You
Go
have a
ahead.
third
But
case to hear, though.
but what's in front of us is, do we
Yeah.
accept what Brian's,
Step.
So
let's make a
let
motion.
Jennifer make a motion.
make the motion?
Let's make a motion to affirm the decision of the zoning inspector and issuance of a notice of violation for a short-term rental use without conditional use approval for the property located at 11,922 Lebanon Road, also BZA 2022-07 appeal, per the staff report.
I second.
Mr. Fowler?
No.
Ms. Harlow?
Yes.
Mr. Horvath?
Yes.
Mr. Trick?
Yes.
Mr. Wolf?
Yes.
Can we make this one?
Okay. Next item on the agenda, BCA 2022-08. 10007 Bent Creek LLC, 1007 Bent Creek Drive, to challenge the determination of zoning inspector that the conditional use permit is required for short-term rental.
Good evening, Brian Snyder, Hamilton County Planning and Development. You should all have a copy of the staff report for this case as well, 2022-08. This is also a request for an appeal to the administrative official's decision to issue a notice of zoning violation to the property owner for operating a short-term rental without conditional use approval. The facts of this case are substantially the same. The dates of the text amendments are the same. The effective date of the text amendment is the same. The date of the notice of violation was June 27th, 2022. All of the findings in the staff report are very similar to the previous case. This case as well is one that did not call or attempt to receive any kind of zoning approval or confirmation of whether they were a permitted use or not. This is something that we would have considered a conditional use had they called, something that has become a conditional use through the text amendment. We feel that it is not legally non-conforming because it was not legal prior to the adoption of the zoning. We would not have told them it was a legal use prior to the adoption of the text amendment, nor did they seek or receive conditional use approval for the subject property. at any point in time, including today. This is an appeal of the determination to issue a notice of violation. Again, this is not a consideration of the conditional use request for any part of the property or for this property, nor the criteria. It wouldn't be appropriate to discuss the merits of this case as a conditional use. This is just about the legal non-conforming status as will be argued by the appellant and her attorney. If you have any questions, I'd be happy to answer them.
Any differences to the first case?
No, our findings on this case are exactly the same as the previous case.
And your position is the same?
The same as the first case, correct. Without the history, this is very similar to the first case as well.
I don't have questions. Anybody else?
I don't have any questions.
Thank you.
Thank you. Those speaking for the appellant.
Good evening, Sophia Hawley on behalf of the appellant, attorney bar number 91361. I'm joined here by my client. I'd like to go through a few questions with her. Could you please state your name for the record?
My name is Iwei Chong.
And are you the representative for the property owner for the property located at 10007 Bent Creek Drive?
Yes, I'm a representative for the owner.
When did you purchase the property?
So this property was purchased, I guess, in January. I don't remember.
January 2022?
I don't remember, to be honest, but okay. Legally, it's January? Okay.
I'd like to direct your attention to the definition of short-term rental under section 31.3-192A of the Symmes Township zoning resolution.
Actually, I believe the property was purchased in October of 2021.
Okay. Well, just to be clear, it was purchased prior to the implementation of the zoning
Right.
restriction on
Yes.
short-term rentals?
Yep.
Okay. And I imagine that the deed shows the property date that's
Mhm.
filed of record. Okay. All right, back to definition of short-term rental. It's defined under the Symmes Township zoning resolution as a dwelling unit or portion thereof, which is offered or provided to a guest by a short-term rental owner or operator for a fee for a term of less than 30 days. Do you understand that definition?
Yes.
How have you used the property since purchasing it?
This was used the same way as short-term rental and a mid-term rental.
Short-term rental and mid-term rental. And was it used as a short-term rental property in 2022 prior to the implementation?
Yes.
Of the short-term rental
Yes.
conditional use requirement? Let's look at Exhibit B to our appeal, which are some documents. Could you please walk the board through what these documents are?
Yes. So in February and March, it just shows an example that in February and March that there were people staying as a short-term rental.
And it looks like this was for a few days, is that right?
Mm-hmm.
And then if you look at the next page, this is from February 1st to 3rd of 2022. Does this reflect that there were just changes being used to the property on your
Yeah, this just shows this was established in February 1.
Okay, thank you. I have no further questions for you. Does the board have any questions?
Yeah,
Yep.
for you.
For me?
No.
Are you, yes.
Okay.
Is your client contending through you that your property is entitled to grandfathered status under the zoning ordinance of Symmes Township?
Yes. That is my position and my client's position.
My question is, when did this become an LLC?
From the very beginning.
Which was when?
So the deed's titled in the name of the LLC from October 21? Okay. And then I have a question because we don't have an affidavit. This is just from a website. How do we know that this is verified and true and a real person?
So she swore that she would tell the truth, the whole truth, and nothing but the truth. So it's her testimony here today. She promised.
Wait, are you saying that I would make this up?
No, I'm just asking because things are redacted, like there's
Okay.
nothing, there's not even
Oh.
a handle like in the other evidence. It's different.
I mean, it's a similar thing that you saw previously in the other case. The name is redacted. I mean, that's personal information of who stayed. That's not going to be disclosed.
We can provide additional testimony, and just to clarify, it is your position that you are telling the truth here, is that correct?
Yes, I mean.
Okay, that's okay. No, I'm not trying to be
No,
combative.
no, I'm not.
She's just trying to clarify for you.
Yes, just for the record. And I appreciate that we can be more clear on the first page after Exhibit B. So it's my understanding that this is a printout page from Airbnb, is that correct?
Yes, I mean, we can provide the same one as the first one if that is more accurate in your opinion,
Well,
which shows the reviews.
We don't necessarily need to do that.
I know you can buy reviews just as easy as anybody else with Google reviews, but there's no, what's the right word for the code at the bottom for the website? That and the redaction is
Okay.
why I'm
I mean, that
questioning
can
it,
be
because I didn't
done.
see that.
Like if we just go back to the website for that date.
I believe it's not the position of staff that this is, I believe staff agrees that this use was in effect prior to the implementation of the short-term use. Mr. Schneider?
Yeah, I'll just read this out of the staff report. Although the authenticity of the reservation history and listing modifications exhibits cannot be verified based on the lack of specific reference to the subject property, staff finds that the property appears to have been offered as a short-term rental prior to June 9th, 2022, based on the information provided on the Airbnb website. You can go on the Airbnb website, find this house, and get that information, which I did and verified that.
Thank you.
Ms. Holly, where is the LLC registered?
I do not have that information, but I...
Does the representative?
Is it the Ohio business?
It's in Ohio.
In Cincinnati, Ohio, or?
It's just with the
It'll be
Secretary of
state.
State.
What's the
question here?
I just want to know where the LLC is established. Okay.
What was the point of your questioning? Who owns the LLC? You know, that's not...
No, that's not at all what I asked. What I asked is if the deed was in the name of the LLC, because I didn't recall it being in an LLC in February. I recall it being in their personal name.
Okay.
So you might be getting places mixed up.
I'm sure the public record, I wish I had a computer.
Okay.
We could look it up.
Yes, I did get them mixed up. This one has not been before this board.
Okay, that makes sense.
Good.
Any further questions for the witness? Okay, thank you for your time, and I'll just give my final remarks. So what we've heard and what we've presented to you are documents and testimony showing that the properties have been used as short-term rental properties the property's been used as a short-term rental property since prior to the implementation of G 2022-52. We've heard testimony showing that the use has been continuous and not abandoned under the Symmes Township zoning resolution. As you all know, because I've said it at least 2 times, there's not a requirement that there was a permit required to establish the conditional use, the non-conforming use after the enactment of G 2022-52. As a result, under Ohio law, it is our position that this is a legitimate non-conforming use. We would respectfully request that the board reverse the decision of the zoning inspector. And for appeal purposes, I state on the record that the appellant intends to appeal any adverse decision to the Hamilton County Court of Common Pleas. Thank you, everyone, for all of your time and attention. Thank you.
Thank you.
Thank you.
It's been a long night.
Anybody here going to talk against?
No, for.
Anyone going to talk for?
Yeah.
Anyone here to talk against? Okay. I
no-
close the testimony and go into deliberation. I'm going to vote the same way I voted before on the other 2.
I affirm as well.
I affirm as well. I don't think.
I'll vote the same way I did before. I disagree.
I affirm.
Okay.
Okay. I move that, I don't have my page open to the paper that I was reading.
Yeah, you did a great job.
I move to affirm the zoning inspector in issuance of a notice of violation for a short-term rental use without conditional use approval for the property located at 10,007 Bent Creek Drive, BZA Appeal 2022-08 per the staff report.
I'll second it.
Mr. Fowler?
No.
Ms. Harlow?
Yes.
Mr. Horvath?
Yes.
Mr. Trick?
Yes.
Mr. Wolf?
Yes. Okay. Is there, next item, is there any old business?
Just approving the minutes.
I got that under administrative matters.
That's administrative matters. Any old business?
Still old business to me.
Any new business?
I don't have anything.
Administrative matters is the approval of the minutes.
We can dismiss everybody. We can dismiss
Anyone approve the minutes?
I wasn't here, so
I wasn't
can't.
here either.
Yes, you were.
I was?
Sure.
Yeah.
We
Oh.
voted
You
you
were.
in. We voted you in.
Oh,
The three of us.
Byron, Jennifer, Gary, and
I move to approve the minutes as written.
Yeah.
I'll second. Okay, you want to vote?
Mr. Fowler,
Yes.
Ms. Harlow,
Yes.
Mr. Horvath,
Abstain.
Mr. Trick,
Yes.
Mr. Wolf.
Yes. I move we adjourn this meeting of BZA, for the October BZA meeting, October 3rd, 2022. All in favor?
Aye.
Done.